One of the questions that many people are asking, who owns the Cooper's Bend property? And even when you give them the answer and call names, they still don't seem to be satisfied. And so I've come to the conclusion it is not the present owners or the previous owners. They want to know the history. So today I'm going to be bringing you the history of the Orange Grove property. Now, the Orange Grove property is being called Cooper's Pen. How it come to be called Cooper's Pen, your guess is as good as mine. But the name on the title and the reference name is Orange Grove. And it was a sugar plantation way back when. And at one time, it had up to 191 slaves working that plantation. Now, the story goes that the Hamden sugar plantation, way back in 1700s, the owners had hired two doctors, two friends, and they came to Jamaica, took a fancy to the island, and eventually in 1770, both doctors purchased a property and built a great house. That great house was called the Orange Grove Great House. Now, as the story goes, Dr. Wright was a student of native herbs and he had used them for their medicinal benefits. It is said that he had 700 verified species of herbs used in his practice, and the suspicion is, of course, that the information that he had was from the African people who were here, who were the ones with that kind of knowledge. He introduced the findings to his peers on his return to England in 1777. But during the time when he was in England, Dr. Steele, who had married the daughter of a local planter in 1775, 2 years before, and fathered 5 children by her. He became ill, though, and died of a fever in 1785. When Dr. Wright had earlier returned to Jamaica in 1784, he was devastated by the death of his partner. He left Orange Grove Great House in the hands of the executors and left Jamaica at the end of 1885. So that was the origin story of the Orange Grove estate. And it gets more interesting. In 1795, it's noted that the Orange Grove estate produced sugar and rum. The records show that in 1796 to 1799, the property was owned by Henry Wisdom Gallimore. In 1809 to 1811 by Jarvis or Jervis Gallimore. And then between 1817 and 1828 by John Stodgdon. There appears to be some 10-year and 7-year gap between the ownerships. The property then passed to Mary Ann Eliza Hyatt, then Pierce. Her maiden name was Tharp, and she inherited Orange Grove in trust on the death of her husband, John Sogben Hyatt, in early 1831, but lost her claim on the property when she remarried in August of the same year. Married a bonnet hat man. And so it all fell to her son, Henry Sogden Hyatt, in whose name the property was held in trust from 1831 to 1834. He evidently was a minor. That was back then. Let us fast forward now to the last century. But the next information we have on the property was in 1904, when it was formally registered under the Registration of Titles Act of 1888. Just a little information for you. Whenever you're looking at a registered title and you see a name of a person first mentioned, usually prominently on the title, what it indicates is that that is a person who had applied for the title in the first place. So that's why their names appeared first. So in 1904, Isabella Maria Louisa Tate, she had brought her land under the operation of the Registration of Titles Act. And it says here that she was the wife of a dental surgeon. And she was now the proprietor in fee simple. And you remember what that means, right? It meant that the ownership of the land by her was indefinite. She held it for the rest of her life, or if she were to sell it or gifted it to somebody else. Now, the title was registered in the Book of Titles at volume 29, folio 7. And you would have remembered that when we were looking at volume 1008, folio 636, that's the title for the land that the squatters are on. It had referred to the land as part of the land comprised in Certificate of Title registered at volume 29, folio 7. That is what is known as the parent title. That's the first title. Whenever the land is subdivided, each lot of land has to have a title of its own. And it is those titles that are known as child titles. Is what I'm saying? Yes. This now is a parent title. And in order to know the history of volume 1008636, we have to turn to this parent title to see who the previous owner was. And we have discovered that it was Isabella Maria Louisa Tate. She was the one who had registered the title. And we are going to look at the owners that came after Isabella to this day, because you hear a whole heap of people talk all kind of things, but them don't know because they never draw the title, talking about it was Seaga and the JLP who handed the property over to these people who own it now. Or you hear them talk about is PJ that sell the property to this person and that person. Well, guess what? This is a title that is going to tell us whether those things that you are hearing was true or not. And then I hope you don't take any more information from liars. You must try and remember who did I tell you the lie, and not take no more information from them because they're not reliable. So here we go, volume 29, folio 7. The first thing we're trying to discover is whether or not Orange Grove is contained in this particular title, or whether it's part of Orange Grove that this title represents. So we're going to read and see. Now, if it says part of land known as Orange Grove, then we know that is only part. If there's no such language, we know that it's the entire estate that is contained in the title. And it's important because remember, all kind of people say all kind of things. So we want to make sure everything is contained. So any lie them tell, I have this title them talk about. You agree? Yes. So we're going to begin. Now I'm going to read it from the title. I had to transcribe because you see it's in handwriting and it's not easy to read. So it begins by saying, Isabella Maria Louisa Tate, the wife of Charles Herman A. Tate of Falmouth, Trelawney, Doctor of Dental Surgery, is now the proprietor of an estate in fee simple, subject to encumbrances notified hereunder in all that parcel or piece of land, being an abandoned sugar estate situate in the parish of Trelawney, known by the name of Orange Grove Estate, containing, by estimation, 705 acres, 1 rood, and 75 perches, be the same more or less, and bounding north on King's Road and Mount Alton Pen, south on Claremont and Dry Valley Plantations, east on Roslyn Castle, Spring and James Hall Pens, and west on Florence Hall. Notice there is no mention of nothing called Cooper's Pen. I don't know where that name come from, but it's not mentioned here. The property is not called Cooper's Pen, it's called Orange Grove, and none of the properties that is bordering is called Cooper's Pen. So where it came from, I don't know, but matters not. It's what the people on the ground call the area that counts, and they call it Cooper's Pen, so be it. But for our purposes, we're going to refer to the property as Orange Grove. Let's read on. He went on to say, saving and reserving therefrom and thereout 2 parcels of land containing respectively 12 acres and 10 acres, and which 2 pieces or parcels of land are respectively bounded and of the shape and measurements as appears by the 2 plans thereof, marked A and B, annexed to a certain indenture of mortgage, Delissa A et al. To Farmer B et al., and dated the 1st day of August 1865, and duly recorded in the Island Record Office and whatsoever other quantity of land the same may contain, or howsoever otherwise the same may be bounded, known, or described. And this title now was registered on the 11th day of February 1904. So this now is what is in the body of the title reference number, volume 29, folio 7. And what it said about the two pieces of land, 10 and 12 acres, they were actually cut off from the original property before the title came into being. That's more or less what that is saying. It's owned by somebody else. The next big question I know you're going to ask, so which part Isabella Sheedy get the property from? That I don't know, but it clearly stated on the title that it was an abandoned sugar plantation. So how she actually came by it, whether she purchased it or she was gifted by the government, or the government had a way in them days that the English people are giving away property to people who they want to reward. So we don't know how she came by the property. It's also possible that the property was owned by one of her family in the past and she was able to lay claim to it that way as well. The fact of the matter is, though, the authorities at the time were satisfied that she is the owner, or perhaps that she had a legitimate claim to the property, and so they gave her a title to that effect. Now, this title had 7 pages to it, so there are lots of transactions. The only ones we're really interested in are those where there's a change of ownership. That will occur when you see transfer or transmission. So we're not going to be looking at those in between, like the mortgages or the discharge of mortgage. We're going to be looking only at the change of ownership. And what we're particularly looking out for is if there was any time that the government of Jamaica, whether it be a PNP government or a JLP government, ever owned this property. The first item you're looking at here is a mortgage. Below that, you have transfer number 4412, which was dated the first day of June 1911. And the registrar said, produced to me and registered both at the hour of 9 a.m. on the 24th day of June 1911. From the above, Isabella Maria Louisa Tate, of all her estate and interest in all that land mentioned and described in this certificate of title, to Charles Costa of Orange Valley in the parish of St. Anne. And he had paid her £750. So Maria had sold land in 1911 to Charles Costa. Charles Costa took out 3 mortgages over the course of his ownership of the land. Thereafter, there was an application number 21241, and it said that the estate and interest of the above named Costa, Charles Costa, in the land comprised in this certificate were acquired by transmission. So he died on the 16th of July, 1939, by Charles R. Scott Costa of Kingston, who was an accountant, and Thomas Eastaway, or Estaway, anyway, by Thomas Dennison of Runaway Bay in St. Anne, and he was a pen keeper. And of course, it was entered the 20th of February 1940. You see how fast probate used to go under them days, eh? So after he died and his interests were transferred to somebody, probably his son and somebody else, the transfer number 43203 was dated the 5th of January and registered on the 20th of February 1940 from the above named Charles R. Scott Costa and Thomas Dennison of all their estate in the land comprising this certificate to Rupert Carlyle Jobson. So no sooner that Charles Costa died in 1940, those that inherited the property sold it to Rupert Jobson. And Rupert Jobson was of Adelphi in St. James. He was an agricultural inspector, and he was not the only owner of the property. It was also transferred to Keeble Winchester Jobson of Kingston, and he was a surveyor. If they were brothers, then they bought the property from the young Costa, right? And they purchased the property for £700. They then took out a mortgage on the property, And after that, there's another transfer at transfer number 62661, dated the 26th of September and registered on the 9th of October 1945 from the above named Rupert Jobson of all his estate in one undivided, I can't make out what that is, in the land comprising this certificate to Gilbert Baron Jobson. So this was how Gilbert got into it. He bought out Rupert's interest. He paid him £750 for his half of the property. And so Gilbert became co-owner with Keeble. They then took out 2 mortgages on the title, and those mortgages were discharged. And then they took out a big mortgage of £6,000 on this title and 3 others from a Robert Henry Pawsey, who was a penkeeper in Manchester. Now, this part of the title was destroyed, but based upon what was said after, it appears as though it was referring to the mortgages being taken over by a Nehemiah Wainwright. Here comes a very interesting part, because in this transfer number 156064, Gilbert had bought out the interest of Keeble. So he then became the sole owner of Orange Grove. And let me read for you what it said. It said transfer number 156064, dated the 30th of July 1960, produced for registration on the 30th of October 1964, and registered on the 24th of November 1964 from the above named Keeble Jobson of all his estate in the 1/2 undivided share in the land comprised in this certificate to Gilbert Baron Jobson, also above mentioned, subject to caveat 27465. Consideration money, £1,000. So this now is the first time since we've been reading that there was any mention of a caveat on the property, right? So what I think happened here, I'm not going to draw that caveat. I'm going to draw another one instead. I suspect when Gilbert and his relative Keeble came to a decision to buy out Keeble's share, remember it took 4 years. The agreement was entered into in 1960, but it was never registered until 64. That could be because that's how long it took Gilbert to find £1,000 and pay Keeble. But then Gilbert would not want to leave it to chance and then Keeble go and sell his half of the estate to somebody else who offer him a better deal. So what's the best way to protect that or prevent that from happening? By putting a caveat on the title. And that is how he would prevent Gilbert from selling his share. So we are in the 60s, and where are we so far? By the 24th of November 1964, Gilbert Jobson was the sole owner of Orange Grove Estate. But no sooner that he became the sole owner, he got very busy. He had subdivided the land and he had gotten title for the pieces that he had subdivided. He had sold a part of it, 284 acres, on transfer number 156065 on November 24, 1964. He had sold the lot for £3,000 to Clive Alexander, and the new reference number for the new title for the piece that he sold was 1008636. That, of course, is a title reference for the land that the squatters are on today. But Clive Alexander was not the only person that Gilbert had sold pieces of the land to. He had cut off an 8-acre piece that he sold to A. Pratt, and then he cut off a 9-acre piece that he had sold to the Orange Grove Restoration Association Limited. In addition to the sale of the 3 lots, he also transferred a portion of the land as easement to all 3 title owners. The next transaction on the title was to register the death of Gilbert himself. It was registered at transmission number 1851208, registered on the 19th day of July 2005. And it said, all estate and interest of Gilbert Baron Jobson to the Administrator General for Jamaica under a grant of letters of administration. So what does it mean? It means that he had died without leaving a will. And when you die without leaving a will, it's known as intestate. And it has to go to the Administrator General, and it's the Administrator General that's responsible for the distribution of the estate. He had 21 children, and at the time when he died, by the way, was 1980. But this is not the final word on this particular title. This is the final entry on volume 29, folio 7. And it says miscellaneous number 1351198. It goes on to say, this certificate of title is hereby cancelled. This is 29.7. The duplicate thereof having been lost, and a new certificate in duplicate, therefore, is registered at volume 1389, folio 427, entered hereon on the 26th of July, 2005. As I understand it, there are two copies of the title. You have the original and what they call a duplicate. The original stays at the title's office. The duplicate is what the owner would have, and they could not find the owner's copy. Whenever there's going to be a change to the title, the duplicate has to be produced so that they can record the information on both titles. So if the duplicate is lost, they have to cancel the title and replace it with a new title. And that was what happened in this case. And on the old original that they have in the title's office, they will make a notation like this to tell the world that the new title number is so and so. So it kind of continue from volume 29.7 onto the new title, which is now 1389, folio 427. Now, what usually happens in this case is that they will simply start where this one would have left off. They won't put what is on this title, volume 29, folio 7, on the new title. They simply will just begin where the old title left off. That is why when you want to know the history of a property, you have to go back to the parent title. Or in this case, you have to go back to the original title that the new title was replacing. And what you'll get is all of the transaction that took place from the time when the title was registered all the way up until the new title that replaced it was issued. So all of the question that you had about who owned the property before the company, New Falmouth Resorts Limited, could not be answered by the title that currently exists, the replacement title. We are satisfying our curiosity and suspicion, in addition to which we are confirming or disproving claims out there that somehow the government, whether it be a PNP government or a JLP government, owned the land and sold the land to the present owner. Not a thing that goes so damn lie. As you have seen, the property was owned by Isabella, who was the one who had registered it in the first place in 1904. She sold the property to Charles Costa in 1911. When he died, the property had transferred to Charles R. Scott Costa et al. In 1940, and in the same year, he sold the property to Rupert Jobson et al. Then, Rupert sold his interest to Gilbert Jobson, and Gilbert became part owner in 1945. The property was then purchased outright by Gilbert in 1964, after which he subdivided the land and sold around about 284 acres to Clive Alexander. The volume and folio for that piece of land sold to Alexander was 1008636. So that was the first piece of the Orange Grove property he had sold in 1964. Then came the 15th of September 1967, and this property was later purchased by New Falmouth Resorts Limited in 1970. And this is the property that has a squatting problem. Gilbert Jobson had entered into an option to purchase the remaining 300 acres of volume 29, folio 7, with the exception of 17 acres. He had entered into the option to purchase with J. Cecil Abrahams, who was acting as agent for the company, New Falmouth Resorts Limited. The purchase price was for £90 per acre for the estimated 300 acres, or £26,900. He later sold the final 17 acres of the original property with easement. He had sold 8 acres to A. Pratt and 9 acres to the Orange Grove Restoration Association Limited, both on the 31st of December 1969. After the sale of those two properties, Gilbert Jobson had no more interest in the Orange Grove property. In other words, he sold them off. He was no longer an owner of any part of it. The Orange Grove property, having started out its life as a slave plantation, seemed not to want to keep quiet, full of drama. And so, when Gilbert had subdivided the land in 4, 3 titles were issued for the 3 pieces of the land that were cut off. However, the parcel of land that he had sold to New Falmouth Resorts Limited through its agent in the option to purchase, that lot had remained on the original title, volume 29, folio 7, the parent title. But before the transfer could be completed to the company, sadly, in 1980, Gilbert had died. He had died intestate, didn't leave a will, and therefore his estate was managed by the Administrator General, who was issued letters of administration on the 30th of December, 1980. That is the history of the property. There is no P.J. Patterson involved. There is no Edward Seaga involved. There is no government entity involved in this property. Damn lie. So now that I've whet your appetite, I can see that I've piqued your interest. You are now wondering what happened to the company and how did they become owners, because you would have noticed, as I did, that their name did not appear on the parent title, volume 29, folio 7. And you want to know how come? What a go on yaso? This is sitting here look funny. Well, as it turned out, there's nothing strange at all about what happened. It happens all the time. Whenever it is that a transaction is going to be noted on the title, the duplicate title has to be produced at the titles office so that they can make notations on the original that they have, and the duplicate, that is usually the owner's copy. Now remember, Gilbert had sold all his interests in the Orange Grove property. Either a family member told the Administrator General that Gilbert owned properties in Orange Grove, Trelawney, or maybe the Administrator General had done a title search and came upon this title in his name. And remember, there was no further transfer noted on the title. And so at this, the mix-up start, and ask if it never mix up. Because the family could not produce Gilbert's copy, the duplicate title, the Administrator General had applied to the titles office for a replacement title, reporting that the old title was lost. Now you're wondering, why would the Administrator General assume that the title was lost? Well, that's because when she looked at the title, she would have seen no mortgage. Therefore, she would have known that no mortgage company was holding on to the title. And if the family has searched down the whole place and then came reporting to her that they can't find the title, then she has no option other than to report the title to the titles office as lost and then apply for a replacement. And so now you want to know whether or not a replacement title was issued. It most certainly was. And the new title that replaced volume 29, folio 7 is volume 1389, folio 427. This is a replacement title. Because it was the Administrator General who had applied for the title, it is the Administrator General for Jamaica that appears as the proprietor in fee simple on the title. However, she would not own the property. she would be holding the property she believed was free and clear in trust for the beneficiaries of Gilbert's estate. So she's like their trustee. When the titles office had issued a new title in duplicate, it had automatically cancelled the old title, 29 Folio 7. When the agent of New Falmouth Resorts Limited had entered into the option to purchase with Gilbert, they had lodged a caveat against the property to ensure that he couldn't sell it without their knowledge. So evidently, when the Administrator General attempted to deal with the property, the titles office would have alerted the caveator, in this case, it's a company, as to what is going on. And so they now would then write to the Administrator General to inform her that they are the legal owners of the property and insisted that the property should be transferred to them. And at this or no, the excitement really started, to the extent that you might become excited about court matters and matters to do with land. Of course, the company would have submitted to the Administrator General the option to purchase agreement between themselves and Gilbert, as well as a proof of payment as evidence in support of their claim. Now, this is a simple matter that could have been resolved very quickly and very easily. But when the Administrator General had written to Gilbert's attorneys at law, who had dealt with the transaction, and asked them whether or not the full amount was paid, they did not respond. So, not sure what to do, the Administrator General had gone to court and asked the court for guidance in the ratification of the sale to the company. And so now, this didn't end up in a court. But today, I'm not only Jamaica 411, I'm also a mind reader. And I can well imagine you're saying to yourself, all right, so is when Michelle will tell me now what is an option to purchase. So we're looking now at what is an option to purchase land. It says an option to purchase land is a legal contract that gives a buyer the exclusive right, but not the obligation, to buy a property from a landowner at a set price within a specific time. The buyer pays an option fee to secure this right while they check financing or permits. So what is it saying? When a landowner decides to sell and a purchaser approaches them, if the purchaser has some specific thing it wants to do with the land, but they're not quite sure if they can get permit for it, for example, they may ask the owner to enter into an option to purchase the land. That option to purchase means that if it turns out when them do them checks that the land cannot be used for the purpose that they intended, they can walk out of the deal. It is for that reason why there is an option fee to compensate the owner for them walking away. And that option fee is an agreement between the buyer and the seller. Now, the seller and the buyer is going to agree as to when the buyer must make that decision as to whether I'm going to go ahead with the sale or withdraw. If the buyer decides to withdraw, then he would lose the option fee that he had paid. It would now belong to the owner. That's his compensation. And if he decides to exercise the option and purchase the property, then he would pay to the owner the purchase price that they had agreed that is in the option to purchase agreement. The owner would then cause his attorney to transfer the title over to the buyer, and he would then become the legal owner of the property. Now, under Jamaican law, specifically satisfying the statute of frauds, an option to purchase land is treated as an agreement for sale of the land and must be in writing and signed by the parties to be legally enforceable. So the first thing that the company has to do, they have to produce the agreement. Word of mouth don't work when it comes to the sale of land in this country. It has to be in writing, signed by somebody, witnessed by somebody else. So this is a position now that we are at. We're going to the Court of Appeal to see whether or not the company had produced the option to purchase, and if they did, what was in it. And folks, stay with me now, because when we go to the Court of Appeal and read the judge's arguments as well as the judgment, we're going to learn plenty things we never know about land and the law. Yes, and it's very important for persons who are seeking to buy a house or buy land, or even if you're thinking about squatting on somebody else's land, that you pay very close attention to what the court said. So we're looking now at the appeal that was made by the Jobson brothers in the Court of Appeal, and they are the applicants, 1 and 2, and you have the respondents, the Administrator General, as well as the new Falmouth Resorts Limited, the company that is claiming the ownership of the land. And we're going to jump right ahead to the option to purchase. So we're looking at the background to the claims, and we're at paragraph 10. Gilbert Baron Jobson was the owner of the lands located at Orange Grove in the parish of Trelawney. The property was formerly comprised in certificate of title registered at volume 29, folio 7 of the Register Book of Titles, but is now registered at volume 1389, folio 427. The company contends that the property was the subject of an option to purchase, dated the 15th of September 1967, between the deceased and J. Cecil Abrahams. The option to purchase provided as follows. So now we're going to know what is in this option. And here the judge is quoting from the option. It says, 15 September 1967, in consideration of the sum of £100, receipt of which is herein acknowledged, paid to Gilbert Jobson, and they gave his address, by J. Cecil Abrahams, and they gave his address, acting as agent for the proposed purchaser. I hereby give you 60 days option to exercise in writing on or before the 13th day of November 1967, that's 1967, to purchase at the price of £90 per acre land known as Orange Grove, believed to be between 300 and 350 acres, more or less, in the parish of Trelawney, with registered title in the name of Gilbert Johnson at volume 29, folio 7, bounded on the north by Main Road from Duncan's to Falmouth between the 78th and 79th mile post, on the east by Springfield, on the south by Claremont, on the west by Florence Hall, west and north by Parochial Road to Florence Hall, less old works area with cemetery, but with rights to well. So here is Gilbert clearly stating in the option to purchase the location of the land, the size of the land by estimation, the title for the land that he's selling, as well as the purchase price. Let us now look at what else was in this agreement. It went on to say, the following conditions shall apply to this option. A, in the event of this option being exercised, the sum of £100 shall form part of the purchase price for the said land. The option shall be exercised by notice in writing to that effect addressed to me at, and he gave his address, accompanied by balance of full purchase price. In the event of the option being exercised, the sale shall be upon the following terms. The land shall be surveyed by vendor, which is Gilbert, cost to be borne by him. Title shall be on the registration of title law, transfer to be prepared by vendor's solicitor and for the vendor's account, but stamp duty, registration, and transfer fee shall be borne equally, and the purchaser's share thereof paid to the vendor upon execution of the transfer. Now, normally, transfer fees are usually paid only by the vendor, but by agreement, they agree to share the cost. The option to purchase went on to say at C, that taxes shall be apportioned at the date of possession. Purchaser shall be entitled to enter the land for the purpose of examination, etc., on payment of the said £100. The purchaser shall be entitled to full possession on the exercise of the option. So you know the terms. Now, I want you to pay very close attention to this, because where Gilbert said that the purchaser shall be entitled to full possession on the exercise of the option, what he's saying is, when you pay up the money for the option, the purchase price, plus the £100, you can immediately move on from the property and take possession, while they may wait for the attorney to do his thing and the title is transferred into the name of the new owners. That's the agreement. And so Gilbert was the one who gave them permission to take possession of the land, which they did. And they had continuous possession of the property from 1973 to this date. Let's find out what happened next. It became necessary for the company to prove that they not only paid the option money, but they had paid it in full, on time, and that they had carried out all of the requirements in the option to purchase, and that they did. One of the requirements of the option to purchase stated that if the company intended to exercise the option, they were supposed to have written to Gilbert and inform him of such. You're looking here at a section of the affidavit that was submitted to the court by the Administrator General. And she said that Mr. Raymond Chisholm, Managing Director of the company, presented her with a letter addressed to the deceased dated the 9th of November 1967, indicating that the option to purchase was exercised on that date in accordance with the terms. Not only did the term of the option to purchase stipulated that if they're going to exercise the option, they should place it in writing to Gilbert, and they should include the full payment of the purchase price of £26,900. We need to check if that was done. And for that information, we now turn to the Administrator General's affidavit that she had filed with the court. Mr. Chisholm presented a bill of costs dated the 5th of September 1969, prepared by Clinton Hart and Company, solicitors representing the company, which indicated that the sum of £26,900 was paid to the deceased attorneys at law. In the absence of cogent evidence that the purchase price was paid in full, authorization was being sought from the court to ratify the sale of the property to the company. Remember, in the option to purchase, there was not a set price for the property. The property was set at £90 per acre. And so a survey needed to have been done to determine what the actual acreage was. They had assumed 300 at the time, more or less. And so this is what the Administrator General was talking about. The option to purchase had stipulated that a survey was to be done to verify the number of acreages, and that the purchaser would pay more or less depending on what the surveyor finds. So they won't be able to do any transfer of the property until they have that surveyor's report. Gilbert had commissioned a survey to be done on the property. He never informed the purchaser, but the purchaser found it nonetheless. And they found out that instead of the property being 300 acres, it was in fact 367 acres, which meant the purchaser had to pay more at the rate of £90 per acre. Let's find out if they did. At paragraph 16, the court said, now, on the 25th of April 2005, Justice Rattray granted the Administrator General's application on condition that the company paid to the Administrator General on or before the 30th of June 2005 at 4 p.m. the sum of £6,000 or the Jamaican equivalent, less the sum of 5,100 Jamaican dollars, the amount that the company paid for the survey plan. They went on to say that on or about the 2nd of May 2005, before it was due, the company paid $661,938.40. And on the 6th of May 2005, another $24,240.80 was paid. Both payments were made to the Administrator General. On the 31st of March 2006, the following year, the registered title for the property was transferred to the company's name. And so the transfer was noted on the replacement title, volume 1389, folio 427. And here is it noted on the title: transfer number 1402382, registered on the 31st day of March 2006 to New Falmouth Resorts Limited, subject to the caveats number, and they name all three of them. Consideration money, £6,030 sterling. And that was because the other money of £26,900, that was already paid over to Gilbert. So the total consideration they had paid for the property was £32,930. So the matter of ownership of this particular property was no easy ride for the company. They had to fork out a whole heap of money to pay lawyers just to get them rights. And when you couple that with the legal wranglings over the 1008636 title that the squatters are on, where the government of Jamaica took them to court, cost them a whole heap of bag of money in legal fees again, trying to, I don't know what, because the court had already ruled that the squatters were to leave the property. And with this kind of problem, when you have titles with a name in it, and you are having all them kind of problem here, we should not wonder if people may not be saying to themselves, maybe this is not a place that we should be investing, and we should not be surprised. Well, folks, this is where I'm going to leave it today. I hope I was able to bring you some clarity on this Cooper's pen business. And if I have done so, I'm going to ask everyone please to give the video a thumbs up, as well as share and subscribe if you have not yet done so. And please let me know what you think about all of this. Until next time, take very good care of yourselves and walk good.